Okay, so today we're diving into something pretty fundamental to how we think about societies and governments and power.
Yeah, it's one of those ideas that maybe seems kind of obvious at first glance, but when you really start to pick it apart, it
Yeah.
gets really interesting really fast.
Right, and complicated too. So we're talking about the rule of law.
Exactly. And to be clear from the start, we're not just talking about like any old rules, like feed the dog before you leave the house kind of thing.
Right, not the rule of remembering to water your house plants.
Right. This is about something much deeper and more foundational to political thought,
Yeah.
to the whole idea of how a society should be governed.
So for our listeners who are already kind of tuned into these ideas,
Yeah.
think of this as like a really deep exploration of a concept that philosophers and legal theorists have been wrestling with for literally centuries.
Yeah, and I think it's a great example of how something that might sound simple on the surface
Yeah.
can actually lead you into some really fundamental questions about justice, about power, about how we live together.
Exactly. So our mission today is to kind of unpack all those layers of the rule of law. And we're using as our guide the Stanford Encyclopedia of Philosophy entry on the topic.
Yeah, great resource, really comprehensive, and gives us a lot to dig into.
Okay, so should we start with where the basic agreement lies, where most people kind of nod their heads and say, yeah, the rule of law, that's a good thing?
Yeah, I think the fundamental starting point is this idea that those who have power, those in authority, they shouldn't just be making things up as they go along.
Right, so no arbitrary rule.
Exactly. The idea is that power has to be exercised within a framework of established public norms. It's like the opposite of just ruling based on personal whims or preferences or just making stuff up on the fly.
So it's not just that there are laws, but it's about how those laws operate and how those in power are constrained by them.
Right. And I think a crucial part of that is the idea of accountability. That if the government itself violates the law, it can be held accountable through legal mechanisms.
So it's not just a one-way street. It's not just the people being bound by the law, but the government itself.
Exactly. And I think the entry makes a good point about the role of citizens in this whole thing too.
Right. It's not just a free pass for everyone else.
Right. There's this kind of implied agreement that citizens also have a responsibility to respect the law, to try to adhere to it, even when it's maybe not convenient, or even when you disagree with a particular law.
Right. So it's not about liking all the rules. It's about having a system where those rules are the ultimate authority.
Right. And if there are disagreements, the idea is that those disagreements should be resolved through legal channels, not through taking to the streets or just ignoring the rules altogether.
And a really crucial part of this whole thing, and I think this is something that people often bring up when they talk about the rule of law, is this idea of equality before the law.
Yeah, absolutely. No special treatment. No one gets a free pass. Everyone should, in principle, have equal access to the law's protections.
Right. And that access has a couple of really important dimensions to it, right? Like it's not just about being able to walk into a courtroom.
Right. So it's about accessibility in a couple of senses. First, the law itself needs to be knowable.
Right. Like you have to be able to actually understand what the rules are.
Yeah, so the rules, the regulations, they need to be publicly available. They need to be understandable, written in a way that people can actually grasp and use to, guide their actions and make plans.
Right. It's like if the rules were written in some ancient language that nobody could decipher.
Exactly. That wouldn't be very helpful. And then the second dimension of accessibility is about the legal system itself.
Right. The courts, the procedures, all of that.
Yeah, so it's about whether those institutions are actually available to ordinary people, whether they can actually use the legal system to protect their rights, to resolve disputes fairly.
And this all ties into things like an independent judiciary, right?
Yeah, absolutely.
Government transparency, having clear established procedures.
Right, because if the courts are corrupt or if the procedures are so complicated that only wealthy people with teams of lawyers can navigate them, then that really undermines the whole idea of equal access to the law.
Right, it becomes this kind of empty promise.
Exactly. So you've got this basic agreement on the importance of the rule of law, but then things get really interesting when you start to ask, well, okay, but what does that actually mean? What does it actually require?
Right, because so far we've been talking in pretty broad strokes.
Yeah, and that's where the philosophical debates really start to heat up. So, as the Stanford entry points out, philosophers tend to focus on the formal aspects of the rule of law.
Okay, so what do we mean by formal here?
So, it's about the form that the laws take, the characteristics of the rules themselves.
Okay, so things like, are they general? Are they clear?
Exactly. So, generality, clarity, the fact that laws should be public so everyone knows what they are,
Right.
that they should apply prospectively so you're not being punished for something that wasn't against the rules when you did it.
Right. No retroactive laws.
Exactly.
Yeah.
And that they should be understandable, that they should be internally consistent so the rules don't contradict each other.
And the idea is that these formal elements, they kind of limit the scope for official discretion, right?
Yeah, so if the rules are clear in general and already laid out in advance, then there's less room for officials to just make stuff up or to apply the rules inconsistently.
So it's about trying to create this system of governance where it's the rules that are in charge, not the individual whims of those in power.
Exactly. But what's really fascinating is that the entry points out this kind of difference in perspective between how philosophers tend to think about the rule of law and how maybe the average person on the street might think about it.
Right, because most people probably aren't walking around thinking about the generality of laws.
Right. So for a lot of people, when they think about the rule of law, what comes to mind are things like the absence of corruption,
Right.
that judges are impartial, that there's a general sense of individual freedom and security under the law.
So it's more about the outcomes, about how the system actually functions in practice.
Yeah, so there's this interesting tension between those two perspectives.
And I think it gets even more complicated when you consider that there's not even agreement on what law itself actually means.
Right. So are we talking about common law, which is that body of legal precedent that develops gradually over time through court decisions?
Right.
Or are we talking about statutes, those laws that are deliberately enacted by legislatures?
Or even a constitution.
Yeah, or a constitution, which sets out the fundamental framework for a legal system.
And some thinkers, like Hayek, they really favored common law, right? They saw it as less susceptible to manipulation than statutes.
Right. Hayek argued that common law, because it evolves kind of organically through the process of judges applying principles to specific cases, is less likely to be used as a tool for social engineering or for imposing a particular ideology.
Interesting.
And even Aristotle, way back in ancient Greece,
Yeah.
he actually suggested in some cases that customary law, the kind of unwritten rules that emerge from tradition and social practice, might be safer than written law because it reflects the accumulated wisdom of a community.
So the very foundation of what we consider law can influence how we think about the rule of law.
Exactly. And this also brings up a question that's really central to this whole discussion, the role of official discretion.
Right, because if the idea is to have a system where the rules are in charge, then what happens when officials have to make judgments about how to apply those rules?
Right. Is any discretion at all inherently at odds with the rule of law?
Because some people would say, absolutely, any room for officials to kind of make their own decisions, that just opens the door to arbitrariness.
Yeah, the argument is that it erodes the predictability and the generality that are supposed to be at the heart of the rule of law.
But then others would say, well, in a complex world, you can't have rules for absolutely everything.
Right. Sometimes you need officials to be able to exercise some judgment, to apply the rules in a nuanced way, to take into account specific circumstances.
So it's this constant tension, right?
Yeah.
Between the desire for clear rules and the recognition that sometimes you need a little bit of flexibility.
Yeah, and finding that balance is one of the big challenges in trying to put the rule of law into practice.
So the Stanford entry actually kind of categorizes these different ways of understanding the rule of law into three categories.
Yeah.
Formal, procedural, and substantive conceptions.
Right. Those are really helpful categories for thinking about the different aspects of this concept.
So we already talked a bit about the formal aspects, so maybe we could dig into those a little more. There's that famous guy, Lon Fuller, who came up with these 8 principles of what he called the inner morality of law.
Yeah, Fuller's principles are really influential in this area. So he talks about things like generality, publicity, prospectivity, intelligibility, consistency, practicability, stability, and congruence.
Wow, that's a mouthful.
Yeah, it's a lot to keep track of. But basically what Fuller is getting at is that for a system of rules to even count as law in a meaningful sense, It has to meet certain basic criteria.
Okay, so it's like, these are the rules about the rules.
Exactly. And what's important is that these principles are all about the form of the rules, not necessarily their content.
Okay, so give me an example of what that means.
So imagine a law that says all citizens with blue eyes must pay double taxes.
Okay, that's pretty discriminatory.
Right, but in terms of its form, it's still general. It applies to everyone who meets that particular criterion.
Right, so just because a law is written in a clear, general way doesn't automatically mean that it's a good law.
Exactly, that's Fuller's point. Adhering to these formal principles is it's necessary, but it's not sufficient for creating a just legal system.
So it's like the foundation.
Yeah.
But you still need to build something good on top of that foundation.
Right. So you've got the form of the laws, and then you have the procedures for how those laws are actually applied.
Right, so that brings us to the procedural aspects of the rule of law.
Exactly. And here, the focus is on ensuring that the legal process itself is fair, that everyone has a genuine opportunity to be heard and to have their case considered impartially.
Okay, so what are some of the key elements of that?
So things like the right to a hearing before an impartial and independent tribunal.
So basically, you have the right to go before a judge who's not going to be biased against you.
Exactly. And the right to legal representation, so you can have a lawyer to help you navigate the legal system.
Right, because the law can be really complicated.
And then you have the right to be present at your hearing, to confront and cross-examine witnesses, to present your own evidence and arguments.
So you're not just being judged behind closed doors without any chance to defend yourself.
Exactly. And finally, you have the right to a reasoned decision from the tribunal, so you understand why the decision was made, and it's not just some arbitrary decree.
And these are all part of what's called due process, right?
Yeah, due process is this fundamental idea that the legal process itself has to be fair, that it has to protect the rights of individuals, even those who are accused of wrongdoing.
And you can see how this really connects to what ordinary people think of when they think about the rule of law, right?
Yeah, absolutely. The entry even talks about the example of Guantanamo Bay.
Right. Those detainees were being held for years without trials, without access to lawyers.
And a lot of the concern about that situation wasn't just about the specific laws that were being used to justify their detention, but about the lack of these basic procedural safeguards.
Right. It just felt fundamentally unfair.
And I think another important point the entry makes is about the institutional aspect of all this.
Yeah, so it's not just about having good rules and procedures on paper. It's about having the right institutions to actually enforce them.
Exactly. So things like an independent judiciary, the separation of powers.
Right. Those things are crucial for ensuring that the rule of law isn't just an empty slogan.
Yeah, it's about creating a system where there are checks and balances, where no one person or branch of government has too much power.
Okay, so we've talked about the form of the laws, the procedures for applying them, and now we get to what seems like maybe the most controversial category, the substantive conceptions of the rule of law.
Yeah, this is where things get really philosophically tricky.
So the basic idea here is that it's not enough for laws to just be clear and general and applied fairly. They also have to be just in terms of their content.
Right. So certain fundamental values like individual liberty or property rights are seen as being part of the very definition of the rule of law.
And this is where you get a lot of disagreement, right?
Yeah, absolutely. Some theorists, like Raz, argue that the rule of law is really just about these formal and procedural aspects of governance.
So the rule of law is one thing, human rights are another thing, and you evaluate a legal system separately based on both.
Exactly. Raz would say that if you start trying to incorporate every desirable political value into the definition of the rule of law, you end up diluting the concept and making it less useful.
But then you have others, like Bingham, who argue that a legal system that systematically violates human rights can't really be said to embody the rule of law, even if it followed all the proper procedures.
Right, and the entry talks about Arthur Chaskelson's analysis of apartheid in South Africa.
Right, where the laws were often clear and applied consistently, but they were still fundamentally unjust.
Exactly. So Chaskelson argued that even though the apartheid regime had some of the trappings of the rule of law, it wasn't a true rule of law because it was based on this deeply immoral foundation.
So it's like, even if the house is built well, it doesn't matter if it's built on a swamp.
Yeah, so this substantive conception of the rule of law is, it's really appealing in a lot of ways because it connects the rule of law to this idea of justice.
Right, it's not just about following the rules, it's about following just rules.
But the challenge, as the entry points out, is that if you go down that road, you risk making the concept so broad that it loses its meaning.
Right, because everyone's going to have their own ideas about what values should be included.
Exactly. So you could end up with a situation where every time someone disagrees with a law, they say, well, that's not the rule of law.
So it becomes this kind of meaningless label that everyone just slaps on whatever they happen to agree with.
Right. So finding that balance between having a concept that's meaningful and having a concept that actually captures what we care about when we talk about justice is, it's a tough one.
Okay, so given all these complexities and all these different ways of understanding the rule of law, why do we even care about this concept in the first place? What's so important about it?
Well, I think even if you just stick to the formal and procedural aspects, the rule of law is valuable because it's a way of trying to limit the potential for abuse of power.
Right, it's about creating constraints.
Exactly. So if those in power have to act within a framework of pre-established, publicly known rules, then there's less room for them to just act arbitrarily or to use their power for their own personal gain.
And Fuller talked about this idea of a bond of reciprocity, right?
Yeah, so it's not just about forcing the government to follow the rules. It's about creating this kind of mutual understanding between the government and the governed.
Right, like we all agree to play by the same rules, and that creates a sense of predictability and stability for everyone.
And Hayek really emphasized how this predictability is actually essential for individual liberty.
Right, because if you don't know what the rules are, or if you think they might change in any moment, then you're basically at the mercy of whoever's in power.
Exactly. So Hayek argued that the rule of law allows individuals to plan their lives with a greater degree of autonomy because they can anticipate the legal consequences of their actions.
And the entry also mentions Bentham, who talked about how law functions to establish and secure expectations.
Right. So if you know that contracts will be enforced or that your property rights will be protected, then you can engage in economic activity, you can make long-term plans, you can build relationships with a greater sense of confidence.
So it's kind of like the foundation for a stable and functioning society.
Exactly. And then, on maybe even a deeper level, both Raz and Fuller connect the rule of law to this idea of human dignity.
Okay, how so?
So the idea is that governing through law, especially when it's combined with these principles of procedural fairness, it shows a certain kind of respect for individuals.
Right, it's treating people as rational agents who are capable of understanding and following rules.
Exactly. And it's also acknowledging their right to have their voice heard, to have their perspective considered within the legal system.
So it's not just about creating order. It's about creating order in a way that respects the inherent worth of each individual.
Exactly. But it's not like everyone throughout history has been a fan of the rule of law.
Right. Even someone like Plato, he had some pretty significant reservations about it.
Yeah, in some of his dialogues, Plato actually argues that wise and virtuous rulers might be better than rigid laws, especially when you're dealing with new or rapidly changing circumstances.
So he's basically saying that sometimes you need someone who can exercise good judgment rather than just blindly following the rules.
Exactly, and he saw laws as kind of a second best option, something you resort to when you can't guarantee that your leaders will always be wise and just.
And that kind of thinking actually has some echoes in more modern thought too, right? Like some people argue that in times of crisis, you need strong executive power, that you can't let legal procedures get in the way of decisive action.
Yeah, you see this with thinkers like Carl Schmitt, who was writing in the context of the rise of Nazism.
Right. And even more recently, people like Posner and Vermeulen have made similar arguments about the need for executive flexibility in the face of national security threats.
So there's this ongoing tension between the rule of law and the need for sometimes making exceptions for allowing leaders to act outside the normal legal constraints.
And it's not just about emergencies. There's also the critique that the traditional understanding of the rule of law, with its focus on clear general rules, it just doesn't really reflect the reality of modern administrative law.
Yeah, so much of the law today is actually made by administrative agencies, not by legislatures.
Right, and these agencies have a lot of discretion in how they interpret and apply the laws.
Exactly. So Rubin points out that we have all these framework statutes which lay out very broad goals, and then the agencies are given the authority to fill in the details through rulemaking.
So the law becomes much more complex and less predictable than this kind of idealized model of the rule of law might suggest.
Right, and this raises questions about whether our traditional understanding of the rule of law needs to adapt to the realities of modern governance.
And it's not just about the practicality of it. There are also concerns about the potential negative consequences of putting too much emphasis on the rule of law.
Yeah, some people argue that it can actually stifle independent moral thought.
Right, if you're always just looking to the rules for guidance, you might stop thinking for yourself about what's right and wrong.
And Cover's work on judges who were forced to enforce the Fugitive Slave Act is a really powerful example of how following the letter of the law can sometimes lead to really morally reprehensible outcomes.
So even if you believe in the rule of law, you have to recognize that it's not a magic solution, that it has its limitations.
Exactly. And there are always going to be these hard cases, these situations where applying the rules strictly might lead to outcomes that just feel wrong.
Okay, so even among those who generally agree on the importance of the rule of law, there's still so much debate about how to interpret it and apply it. And the Stanford entry highlights a bunch of these specific controversies.
Yeah, things like the proper scope of discretion, the trade-offs between rules and standards, the relationship between law and social norms, how to uphold the rule of law in times of emergency.
And it's not just theoretical, right? These debates have real-world implications.
Yeah, absolutely. Think about the debate over whether it's better to establish rule of law institutions first in developing countries, or whether you should focus on democratic institutions first.
Right, those are really big questions with potentially huge consequences.
And then finally, there's this fundamental philosophical question about the relationship between the rule of law and the very concept of law itself.
Yeah, we touched on this a little bit earlier, but it's worth revisiting.
So some legal philosophers like Fuller and Dworkin argue that certain principles of legality are actually part of what it means for something to be law in the first place.
So they're saying that a system of rules that completely ignores those principles, that's not even law, it's just brute force.
Right, and this view suggests that there's this inherent connection between law and morality, that law can't be completely divorced from considerations of justice.
But then you have others, like Raz, who argues that the rule of law is a separate set of moral and political ideals about law.
Yeah, so for Raz, you can have a system of rules that meets the definition of law, but still fails to live up to the ideals of the rule of law.
So it's a way of keeping these two concepts distinct, of saying that you can analyze a legal system in terms of its formal and procedural features without necessarily endorsing it morally.
Right, so it's a more analytically precise way of thinking about the rule of law.
Okay, so after this really fascinating deep dive, I think the main takeaway for our listeners, especially for those who are coming at this from a philosophical perspective, is that the rule of law is not some simple, easy-to-define concept.
Yeah, it's incredibly complex, and there's a lot of disagreement about what it means and how it should be applied.
But I think even with all those disagreements, there's this recognition that the rule of law is striving towards something really important.
Yeah, it's about trying to create a system of governance that limits the potential for abuse of power, that protects individual liberty and dignity, that provides a framework for social cooperation and predictability.
And it raises all these really fundamental questions about the nature of law, the relationship between law and morality, the balance between order and freedom.
And for you, our listener, as you continue to think about these issues, I think a really interesting question to ponder is this. Given all the different values and priorities that people bring to this concept of the rule of law, which aspects do you think are most essential for creating a just and functioning society?
Because there's no easy answer to that question.
Mm-hmm.
It really requires you to think carefully about what you value most and how those values can be embodied in a system of governance.
So we encourage you to continue exploring these ideas, to read more about the thinkers and debates that we've touched on today.
And we hope this deep dive has given you a good starting point for that exploration.
Thanks for joining us.
Until next time.